You can use the chat box. You can also use the reactions. Thank you. Thank you very much. So we're really glad to have you here this afternoon, and we hope that you stay with us till the end. And I also want to use this opportunity to specially acknowledge our guest this afternoon, Mrs. Zakiya Aruna. It's so good to have you here, ma. Please, can you hear us? Hello, ma.
Hello, can you hear me?
Yes, yes, I can hear you, ma. Thank you so much for joining us, ma. We're so
Thank you
glad
for
to have
having
you
me.
here.
I'm glad to be here as well.
Yes, we're so glad to have you.
I can't see you
So,
though.
yes, my video is off. I'll put it on now.
All right, thank you.
Yes, ma. You can see me now.
Hello.
Hi, ma'am. Good afternoon.
Hello.
Yes, so this session this afternoon is designed to be very thought-provoking and knowledge sharing. And we also encourage you to drop your questions in the comments as we go so that we can read them and ask our guests the question. So we'll be starting now, and I'll be reading the profile, the very intimidating profile of Mrs. Zakiya Aruna.
Oh, come on. Not
Yes,
at all.
yes, sir. The
Hello.
I can hear you, ma. Zakiya Aruna is a legal scholar and practitioner with over 14 years of prosecutorial experience at the Kano State Ministry of Justice, where she secured convictions at the State High Court, the Court of Appeal, and the Supreme Court of Nigeria. She also served in leadership roles at the Kano State Public Complaints and Anti-Corruption Commission, including acting director of the Citizens' Rights Department and the Public Complaints Department. In these roles, she mediated disputes between government agencies and between citizens and public institutions, and prosecuted high-profile corruption cases. She further served as the registrar of the Kano State Anti-Corruption Institute, where she chaired the External Cooperation Committee and contributed to staff training and institutional capacity building. She holds a master's degree focused on situating restorative justice within the Nigerian criminal justice system, and is currently pursuing a PhD on restorative justice in corruption plea bargains, enhancing public interest through community participation. She lectures at Northwest University Kano and has published in both local and international journals on corruption, plea bargaining, and comparative contemporary Islamic law. Ladies and gentlemen, please join me as I welcome Zakiya Aruna. Welcome, Ma, once again.
Thank you for having me. I'm glad to be on the platform.
Thank you, Ma. I'll be reading the profile for our second guest. Another intimidating profile, if you ask me. Um, Osarimen Grace Shobanke is a Nigerian lawyer, social entrepreneur, and the founder and executive director of Restorative Justice for Africa, REJA. She started REJA in 2020 during the global pandemic, moved by the desire to reform the criminal justice system and address the injustice faced by people who were incarcerated simply because they were poor and unrepresented. Since then, she has led the organization to support over 14,000 justice-impacted individuals across Nigeria through legal aid, restorative justice programs, and reintegration support. Grace is a Mandela Washington Fellow, a Fellow of the United States Institute of Peace, an Echoing Green Fellow, a Dovetail Acceleration Fellow, a fellow of the Hague Institute for Innovation in Law, and most recently, a Civic High Fellow. In 2023, she had the opportunity to attend the fourth high-level political forum at the United Nations headquarters in New York, where she made a compelling case for restorative justice as a global strategy for dignity, reintegration, and systemic reform. She successfully established the first halfway home in North Central region of Nigeria in 2025 July. She is also a recipient of the Future Awards Africa Prize for Advocacy, the winner of the Active Citizens Award, and the Innovators Award in Global Affairs in New York. Through her work at Regia, Grace is deeply committed to promoting people-centered justice across Africa. Ladies and gentlemen, join me in welcoming Grace Shobanke. Can you hear me, ma?
Yes, I can hear you.
Thank you so much for joining us today, ma. So, to start with, I'm very sure that people on this call, on this webinar today, who do not have the faintest idea of what restorative justice is. So it is very important that we start with that. So I'll be starting with Mrs. Zakiya. Can you please give us a very brief general definition of what restorative justice is, ma'am?
Thank you very much. Restorative justice is a kind of justice that calls for an entire paradigm shift. Like it's completely opposite of what we know in the criminal justice system. Its focus is mostly on repairing harm and also looking after the interests of not just the accused defendant, as it is in the criminal justice system, but also look squarely at the interest of other members of the community, like victims and the community members as well. So it has a lot involved in it because it believes that crime is not a violation of the state law. No, a crime is a wrongdoing that violates the victims personally. Victims are the ones who are most hit personally by the crime that occurs, right? So restorative justice sees it as something that should be addressed personally for the victim rather than the state, which I always say or call it like a state abstraction. Because when always you say the state is the victim, you can't really see the state, right? You can't. The only thing you can see is that you can pinpoint a particular witness who has been, a victim who has been wounded, or a victim who has lost his property as a result of a crime, or a victim who has suffered some financial benefits in cases of financial crimes, right? So you don't really see who the state is, but you can see and identify victims who are really suffering the brunt of that offense. So restorative justice focuses more on that victim, more on the harm and how it affects the victim himself and how the community is generally involved, because it believes that restorative justice is, what do you call it, relational. It believes that we all don't exist in isolation, but generally a crime that affects one person, one way or the other, affects or impacts the entire community. I'll give you an example. How I'll always put it is that this general kidnapping that happens along the Kaduna-Abuja route, right? There are actual victims who are being kidnapped, but the community members or the populace in general, citizens, are also victims because many people now are afraid of trading that route by road. So impliedly, the people generally are also victims of that crime of kidnapping. So unlike the criminal justice system that defines the crime as a violation of state and also puts emphasis on the accused person from the beginning to the end of it, and also tends to marginalize the victims of crimes, restorative justice is more holistic and gives a broader picture of how to take care of the entire crime, putting all the stakeholders that are affected by the crime in the entire process. That's just a simple way of describing what restorative justice is. Thank you.
Thank you very much, Ma. That was very educating. Mrs. Grace, do you want to add anything to what she has said?
Yes, I think thank you so much, Zakia, for that point, especially highlighting the fact that crime is crime is against a person, an actual victim, an actual human, and not just an abstract state like we currently have in our criminal justice system, where crime is seen as an offense against the state. So you see that in a magistrate court, the prosecuting authority is the police, and then so it reads COP versus, and not the actual person who was hurt or who was harmed, right? And so RJ is coming as a force, as a principle, as we can, however, in however way we want to adopt it, but as a way to see and center the real people. As a way to put the people who have been most affected at the center of resolving that crime. So our current criminal justice system just focuses on what has been done. It just looks at the laws, what was broken, right? And then what punishment is supposed to inure to the person who broke those laws. But restorative justice takes it a notch higher. What happened? Who was affected? Why did it happen? And then what can be done to resolve or to restore what happened? And then let me also add that, as much as we advocate for restorative justice, and like we're always saying in the among ourselves in the Regia team, restorative justice is not that silver lining that solves the entire problem of the criminal justice system. It just makes it a lot better. It just puts human faces, it centers people, so that you're not talking about institutions, you're not talking about abstract things, you're talking about real lives, you're talking about humans. So it's not a model that solves all the problem, because if you take a look at murder cases, for example, where irreplaceable harm has been done. So no matter what type of justice you try to advocate in that scenario, it cannot bring back the dead. And so to that extent, we don't try to use restorative justice as that alpha and omega so that you make the person feel like, oh, this is the complete and absolute solution to your problem. It just makes the criminal justice system safer, better, more humane, and restores more relationship. So I hope that context helps. And if there are more questions around what restorative justice is, we'll be happy to answer it as the meeting progresses.
Yes, there are definitely questions, because the concept of restorative justice, it is very new for one, and secondly, it's not vague, but it raises a lot more questions. And while you were speaking, I got one of them. So you mentioned that it focuses on why a crime happens. And in the same vein, in the same breath, you did say that we cannot solve the whole problem. It's not a silver lining. So my question is this: there's always a reason why every crime happens. That there is always a reason. If you ask the most vile offender, they will always have something to say about why the crime happened. So my question is this: say for instance, in the case where someone stole something, and the reason is, oh, I didn't have money to eat at that time. Are we saying that restorative justice is saying, if we find him food, maybe he will not steal again? Is that the kind of picture that you were trying to paint when you said that?
Thank you so much for that question, because we get it a lot in the line of work, and I think Zakia can add from where I stop. So with the example you just shared, it's a very classical example of why we should center restorative justice and not just put people and put labels on people as though crime is a desire of people. So let me say it. In criminal jurisprudence or in criminology, we normally say that people don't just commit crimes, right? People don't just wake up and the next desire is to want to steal. People don't just wake up and the next desire is to want to kill or harm, except their underlying psychological problems. Right. Except there are mental health issues, except there are psychological or psychosocial problems that they are going through. So, and which is always in the minority. So the reason crime occurs is because there are needs that have gone unmet. And what RJ does is to see how those needs can be brought to fore. So let me bring your example. You said if someone is hungry, right? And the person, whether I'm trying to not, do you want to share that example again? I know I got very clearly the fact that someone, was hungry and then committed a crime in the course of seeking what to eat.
Yes, so I asked if we're saying that restorative justice is supposed to solve that problem of poverty, just so it doesn't commit another crime or a similar crime in the future.
Exactly. So that's the goal, to see how that problem can be solved and how that crime will not be repeated in the future. And one way restorative justice does this is to ask the very necessary and relevant questions. For poverty-related questions, we already know the background. We already know many of the foundational questions. Oh, I don't have a job. Oh, but what restorative justice does is to shift their lens, right? From looking at the person who they victimized as the person who should solve their problem, rather than to make them see how they can solve their own problem without victimizing another person. So let me give you a clear example. If you bring that person who stole and explain to them that the person they stole from was also hungry, and what they stole was also someone's only food, it's a better way for them to understand that crime has ripple effects and crime affects real human beings. We have done it severally in several RJ circles, and you hear people say, "Oh, I didn't see it like that. I just thought about myself." There was a guy who snatched a bag, and was very early. The lady was coming from, I think, a vigil or something, and he was going with a bike and snatched her bag, and he was caught in front because he was in the habit of doing that. And because they knew that he was in the habit of doing that, we decided to use the restorative justice model to try and resolve that crime. And then we asked him why he was doing that. And he said that bag he snatches most of the time is what carries the food he eats for the day. So that is like his own day job. While people are going out early in the morning to search for what to eat, that is what he feels will give him food, because he feels there's no other job. So he was relaying examples of what he has done in the past and he got nothing. But with this, he's almost always assured of something to eat. And then this particular victim shared her story of why she went to church to pray that night, and the fact that the money she was coming back was her own only means of survival for that day. So you could see the remorse in his face. You could see the remorse in his mind, in his countenance. And it was like, oh, I never saw it that way. For me, I was only thinking about myself, what I can eat. He did not imagine that he would listen to someone say that what you took from me is the only thing I would have also eaten for that day. And that changed the perspective, changed the balance of how he saw his little hobby, right? For him, he was getting away with it. And if that kind of person was put in prison, it wouldn't have solved that problem, because he didn't understand it from the victim's perspective. And that's what RJ tries to do. You get to hear it from a very different perspective. And then you get to see that your actions are actually harming and hurting others. So it's not like it's not going to completely solve that problem for every person, but for the most people who eventually get to be reformed through that process, through the RJ process, it's an opportunity to give them another chance so that they don't become hardened offenders. So if you take that example of someone who is stealing plantain, stealing and snatching bag just to eat for that day, and you put that person in a correctional facility where you have more organized crimes, you are going to have someone, you're going to be creating, modeling, building, and you're creating the next hardened offender. Because during that time, it's going to interface with people who have done it in a more organized way, that they would clean their traces. And when it's coming out with those dark wisdom that it will be more difficult to reform him at that stage. So we are saying, for the people who can still be saved, for the people who are doing it not because they are hardened, not because they have criminal tendencies, but because they have needs, let's try and repurpose them. Let's try and see how these people can find a different means of, meeting their needs, rather than harming or offending others to perpetuate this cycle of crime. So I don't know if that explains the role RJ is playing in the criminal justice system, because it's a very germane question you asked. A lot of people have that question. In fact, that's one of the strongest criticism against restorative justice. Because it feels like you are excusing crime. No, we're not. We're just making people understand, the impact of crime. And with that understanding, they are able to have a change of lifestyle.
That was very educating. And it did answer one of the major misconceptions that people have about restorative justice. In fact, when I myself first read about it, it did feel like, are we not going too far? But now that you explained it, it's made more sense to me, and I'm sure to a lot of our listeners too. So I also have a question for Mrs. Zakia. While you were speaking, you did say that restorative justice does not see crime as something that is done against the state, because the state cannot actually be a victim. There are real people who these things have happened to, who are victims of harm done, and restorative justice centers them more than it centers the state. So my question is this: one major concern that people have about restorative justice is that it defeats the purpose for which the state punishes crime. If we're saying there's a criminal justice system, we say it is there because the state punishes a crime, and that is exactly what distinguishes it from civil law or civil cases. In fact, as law students, when you're being taught civil law and criminal law, one of the first differences, or the first difference they teach you, is that, oh, it is the state that punishes the crime in a criminal case, and for a civil matter, it is the complainant that is bringing the matter before a judge or before a court. So does it not defeat the purpose of a criminal justice system if we're saying, well, we should center the victim? Why not just bring a civil case? Because there are actually matters that would fly in civil law if you bring it as a civil matter instead of a criminal matter. So I'm trying to understand, and I want you to explain to us why you think, or why restorative justice is not encroaching on the state's right to prosecute in a criminal justice system.
Thank you very much. Can you hear me?
Yes, I
Hello?
can. Yes, I can.
That's a very, very good question that you asked. But before then, I would add one thing to what Raja said about focusing on the harm, why the harm occurred. I want to add one thing to that is restorative justice focuses, like I said before or earlier, focuses on the crime victim. But I also said it's also holistic. Like it's an entire paradigm on its own and has its own way of dealing with crime, which is not quite the same that we have in the criminal justice system. But that doesn't mean that it is any less, or the criminal justice system is any less as well. They're just two paradigms. I hope you understand. They're just two ways of seeing crime. Okay, so part of it, for instance, is asking the question why the crime occurred. Why is very important because restorative justice focuses, like I keep saying, on the victim, on the accused defendant, and the community as well. So in as much as it's interested in the victim, it's also interested in the defendant, so that the defendant gets what, rehabilitated, in such a way that he doesn't commit the crime again. It's preventive, right? So his whole character during the process will be interrogated. And like she said, it's more of a social thing, not like psychological. Apart from being psychological, there's also the social aspect of it, looking at the environment where the accused person is coming and why he did the offense. So if, for instance, the victim will see it in another way, oh, now I see why he did it, the victim himself will be willing to help him. If he was looking for food, that's why he stole the food. The victim will now understand, oh, he was probably very hungry. I could give him food, or I could sponsor his breakfast every morning and even offer him a job so that he gets something to eat for himself. Well, without further digressing from the question that you asked about criminal law and the criminal justice system and the state itself, I think that would go in deeply into the history of how the criminal law or the criminal justice system evolved in the first place. If you know the history, you would understand how the state came into being as an abstraction and how, according to some write-up, will say that the state actually stole the dispute from the victims. Right from the word go, initially, right ab initio, all cases, there wasn't that division between crime or civil wrongs. A wrong was a wrongdoing. You will have community members coming together, the defendant, the accused person himself, the victim will sit and resolve their own conflicts. They will decide, talk about it, what happened, how he's going to take accountability for his offense, and the whole dispute will be settled. And that was a system that was the golden age of restorative justice. But however, in Europe, after the Norman conquest of Europe, the whole thing shifted, and the power of the crown at that time in England was becoming very weak and weaker and weaker. So part of it was to cling to its power, and because it didn't want to lose all of it, so it decided to create some kind of state offenses and call those offenses that were a threat to the crown. So if you were caught doing those kind of offenses, they became offenses against the state, and as such, the state you were directly attacking the state. So they will hold you responsible, and also you'll be asked to pay some fines, and that fines goes directly to the pocket of the crown. So even if it was losing its powers, but it was still getting some kind of monies coming from the people, because the powers were gradually being seceded. So that was the beginning. And because of that, the crown was still very powerful at that time, and it introduced these kind of offenses. There was the grievous need to protect the interest of the accused person, because the crown at that time was very, very powerful. So the defendant needed to be protected from the powers of the crown, I mean. So that was how these things were brought to us through colonialism, right? And all their laws, all their statutes, and even at that time during the colonial period when it started, at that time they were trying to find way out of that system themselves, but it was brought to us, we adopted it, and then it became constitutional, and then it got grounded into our own system. But even as at that time, the system that was being applied in most communities that formed Nigeria today after the amalgamation, all practice restorative justice. For instance, in the northern parts of the country, you have the emir, and the emir was the chief imam and the chief of the quarters. That at that time, all disputes were resolved by him. In the eastern parts of the country, you have the village circles and the age grade system. And also in the western part of the country, you had the Obas and the Alafins. They were all there. So disputes were not generally at that time separated, what is criminal, what is not, and everything worked well, mind you. Everything was fine till the coming of these laws. And when they did, what they did was that they protected through the Constitution more of the defendant's right through Chapter 36, and the victim became more and more oblivious in the entire process. So if you were to ask me whether there should be a shift or not, I'll tell you there's no shift. It's just that the paradigms are completely different on how they look at offenses and how they deal with them. And that's just it. It's just a system that was created by the colonial masters who were actually using it to serve their own interest at that time, really to protect their own interest, the crown, not really the defendant or the accused or the victim himself. I don't know if that answers your question.
Yes, yes, it does, ma'am. I now understand that, in essence, adopting restorative justice is almost like going back to our origin, to how things
Exactly.
works originally before the
Yes.
colonial masters came. That's
I just
very
want you to
right.
understand that it's the criminal justice system is just a creature of the law.
Yes,
So it just
yes.
defends it because it has a lot of interest in it. And at that time, I even forgot to add this. There was a lot of when the state was created formally, because before it was the crown, and then with the introduction of the system of state, it collected all powers from everyone, and after collecting all the powers, in return for what? Safety for the people. And that brings us to the social contract theory. So everyone will give his powers, will relinquish all his powers, his rights, and give to the state, who will in turn provide safety and security for the people. And that's why the whole idea of all offenses are against the state, right? But in the process, now that the state has been created and all the wrongs that have been committed are crimes against the state, it left out the victim completely and took over the disputes and took over the control, and even in the process forgot about who the victim is. That's how it all came about, really.
Thank
I
you
don't
very
know.
much, ma'am. It makes a lot of sense now. So, on that premise, I want to ask that, in your view,
Yes.
in what ways does the current criminal justice system in Nigeria fail the victims most? Because restorative justice is trying to center the victim. It means that we think that the current system actually fails the victim. So, in what ways do you think the victims are failed the most in this current system? And how do you think restorative justice helps to fill that gap?
Oh, yes. Well, if you've been a prosecutor, you would know this. The first thing that will hit you as a prosecutor is the realization that the victim has been forgotten. Everything about the Constitution, Section 36, the right to fair hearing completely, and the due process rights are all what are tuned towards the defendant, the accused person. There's hardly anything constitutional about the victim. So in essence, it means the victim has no right. The victim cannot decide whether his case goes to court or not. It's the prosecution that decides that under the powers of the Attorney General, right? The Attorney General decides through his officers and by himself which offense should be prosecuted and which offense should not be prosecuted, which offense, even after the initiation of a criminal trial, can be stopped by a nolle. The victim cannot say anything, anything. He doesn't have a right. The only thing he can do, perhaps in civil cases, is to appeal. And even if he has anything like a kind of audience, probably would be through watch and brief. And guess what? Watch and brief is not constitutionally recognized. It's just a practice that developed out of nowhere. And even the watching brief himself cannot even object. And he cannot force the prosecutor to bring any evidence to court which he thinks would be helpful. So I don't even know the essence really of a watching brief. Now, if you have been in the ministry, you will see the victims coming in, and you know that they're even intimidated by the system itself. The lawyers will be there all dressed up, looking lavish in their offices, but they're not even provided a single room where they can even sit, waiting room. So many times I would call the messenger and say that there's going to be a victim coming for a witness interview. Please kindly open my office for him because they don't have any waiting room. And sometimes when they do come, you would have to like feed them, like maybe give them lunch or maybe give them some kind of transport money to go back. They spend all of their days, most of their days during this trial, on their way to court, some of them coming from villages, some of them leaving their offices, some of them leaving their markets for the entire day to go to court. And even the court sometimes will not sit. But they will waste their entire day losing incomes, losing opportunities with no remorse on the part of the criminal justice system. Nothing, nothing. It's only when you have like apathy for them that you would consider them. Personally, I take it upon myself to like take care of the victims. All the victims that I've worked with, I would call them, tell them the progress of the case, tell them what happened on court, try to explain things to them, why the case was adjourned, why they need to come, and so on and so forth. And you know what? If they don't come, I've also had situations where victims, particularly in rape cases, they just don't want to come to court. You might have to force them or compel them to come to court. And if you tell them to come, they don't have like anything but to come. They could be subpoenaed. You know, they could be subpoenaed to come to court by force. So there's nothing really that gives them the right to say, I want to come to court, or I don't want to come to court, or I've already settled this issue with my ward head. I've had cases like that. But there's nothing on ground that protects their interest. I don't know, but you see in European countries or in the US or UK, you have the Victims' Rights Act. But sadly, in Nigeria, I think only a few states in the South actually have that victims' rights, but they don't. They don't. So I'm prosecuting, but I'm only prosecuting on behalf of the state. I'm not their counsel, and I'm not obliged to listen to them. I do so only at my own discretion. So the entire thing is sad because they're the first people that move the wheel of the criminal justice system by reporting that a crime has occurred at a place. But then throughout the process, they're left without a voice. They're not heard, and they don't have a say in the ending of the sentence. Nothing. So that's pretty how much the victims have been sidelined or marginalized. I hope that answers your question.
Yes, it very well does. And, it reminded me of one day in court very recently when I started working at Regia. We went to court and this young man was charged with stealing. And the nominal complainant in the case was in court on that day. And then she told the judge that she had already forgiven him from the bottom of her heart and she does not want the matter to go on. And she was not even learned, she was an illiterate. And it took a lot of people to start explaining to her that, oh, it doesn't actually work that way. You cannot say you've forgiven him because at this point it's the state that is prosecuting. And the young man was eventually convicted and all. So it reminded me of that experience that whether or
That's
not she
exactly
forgave
what I
him.
would say, that the disputes are being stolen from the people, from the
Yes,
parties.
yes.
The state steals them. The victim and the defendant might want to reconcile, but no, the state will not allow it. It just closes the door for that kind of conversation. It does.
Yes, yes. That makes a lot of sense. So how do you think that restorative justice can fill in that gap to ensure that victims are not sidelined in their own matters?
Yes, that could be done. That could be done through reforms, because right now, I think restorative justice has come in through the ACJA, but I still think a lot needs to be done. How about creating a Victims' Rights Act or law that would ensure this? And when it's done, it should be couched in a way that is mandatory, that victims do have rights rather than privileges. But that might be a bit too punchy for a start. Maybe all states to recognize as some kind of privileges, victims' privileges in criminal prosecution, right? At least let's take that baby steps and then we move into the rights, right? I mean, if we have that kind of reform, that will go a long way to help. And then secondly, don't underestimate the powers of the Attorney General. Attorney General is a power unto himself. I mean, he is the only minister that is categorically mentioned Attorney General in the Constitution. All other ministers says offices of ministers should be created, but the Attorney General is particularly mentioned. The office of Attorney General shall be created under section 211, right, of the Constitution. Yes, 211 or 121. So another thing is, if AG has so much discretion to prosecute or not to prosecute, he could bring about guidelines in the Ministry of Justice on how the victims should be treated, right? Secondly, I think the heads of courts do have a role to play as well through practice directions. If they issue a practice direction directing all judges about the guidelines of how to treat victims on court, particularly, let's say, regarding an adjournment, maybe for any time that a case was called and a witness was on court and the prosecution was there or the defendant was not there, there should be some kind of compensation for that, right? So I think NGOs can also push that down as well. I know of ROLAC. One time, ROLAC, I was at a meeting and ROLAC was, representative of ROLAC was saying that they did some work in the court premises for the court users, like they used signposts directing the court users and putting up stickers like you're not supposed to pay money at so points. Payments are to be made there. You should meet the registrar for this. Registrars are for doing this and that, all over, just so that they enlighten the court users about where to go and also to avoid certain kinds of corruption within the court premises. But that's just for the court users. And the court users are many. They could include the victims, right? If they could push something like that, I believe they could push for victims' rights to that. And there's also this justice sector reform team. I was a member at some point in time from 2012 to 2023. I was the secretary, assistant secretary. So the justice sector reform in Jigawa has become a commission. In Kano, it is just a team, even though it has been legalized with the Kano State laws, House of Assembly. So it's a composition of all stakeholders in the criminal justice system that sit monthly to discuss issues that affect the justice system. If we could push this kind of idea that victims should also be protected, probably the laws will be amended to include the victims' rights committee, or even restorative justice. Yes, or even restorative justice as some kind of complementary system. And I also think this gap could be closed by diversion. Just like you can divert ADR cases from the courtrooms to ADR multi-door courthouses, right? You could also have a diversion of cases that could go to restorative justice programs. You could have those kind of programs running in the court, just like the multi-door, because multi-door deals mostly or entirely with civil litigation, right? So the restorative justice could have this kind of diversion to restorative justice programs from the court. And that will do a lot. I mean, if there were guidelines that, like I said, from the Office of the Attorney General for the prosecutors to look one-on-one into those cases and their facts, if they meet the requirement for restorative justice, then fine, fine. Before even preferring a charge, opt for the restorative justice. But also the judges as well, if they find that the elements of the offenses or the parties and their demeanors, the court could refer them to the restorative justice program outlets of the court as well. So it all depends on really how we want it to be done, but it will be done. And I will also add to this that whether you like it or not, whether we like it or not, restorative justice is happening behind closed doors. Yes, it is happening. So I personally, I believe it should be legalized to avoid, like, let's say, abuse of the processes and to ensure its validity and authenticity so that it's endorsed, right? Because whether you like it or not, these things are happening. I once had a case and I literally kept begging, persuading the victim and her parents to come to court. But the father of the victim, of the complainant, kept telling me that he had already resolved this thing with the defendant together with the ward head. And he doesn't want to go back on his word. Everything has been resolved, everything has gone back to normal, and they're all respectful people, respected by each other. And he's doing his own part. The defendant has kept to his own terms, the victim as well, and her parents, her family as well. And the ward head who had reconciled everything. So you see, this has already been settled, but I insisted that the case had to come to court. It had to. Eventually, he budged in, but he felt humiliated because he became like a hypocrite in the neighborhood. Do you understand? It became very difficult for him as someone that has turned back against his words. So whether we like it or not, these things are happening. So we just need to like accept it and formalize it. I don't know if I've answered your question.
Yes, yes, fine. You have. You have. So to Mrs. Grace, are you there, ma?
Yes, yes, I am. I can
Yes.
hear you now.
Yes. Do you want to add anything to what she has said so far?
I think she excellently covered the field. In fact, this is one of those times when I get to hear the perspective, very raw perspective from the states and from the prosecutorial authority. And the reason I say this honestly is because on the field, we mostly have resistance with recommending restorative justice to prosecutors. It's always as though we want to determine how the case will go. We want to silence the voice of victims. And so the recommendations are not always accepted, right? And so it's so refreshing to hear you talk about it from a very, from an insider perspective. And I have noted one or two of your recommendations as well. I know we have been pushing for victims, adoption of victims' rights, as well as practice directions on restorative justice that clearly states how restorative justice should go, how it should be practiced, how referrals should be done, and the very, very key thing you mentioned about how cases should be assessed before legal advice is preferred to see if it can be resolved with restorative justice, especially cases where you have communal feuds, family matters, and cases that are clearly not relevant. Well, let me take that back. Clearly, right. cases that would not
You don't
benefit
need to
any
go
of
to
the
court.
parties.
You don't
Right.
need to waste the resources of the
The
government. You don't
time,
need
the
to
resources of the court.
politicians' resources.
So those
Yes.
kind of matters that would not be beneficial to even the victims or the offenders, those cases can be resolved using restorative justice. So I noted that. And something you also mentioned about organizations not, promoting restorative justice. That was one of the reasons we had to see how we can be part of the voices for victims. I remember how one time they told us, because we visited the defendant in the correctional facility, and then we came to court, and because we mentioned that fact that we visited the defendant, how else were we going to meet or know the defendant in that case? Because at that time, there were no referral mechanisms, there were no RJ centers. So the only way we got cases was by going to correctional facilities, listening to the people, and then coming to court and then recommending restorative justice, because the ACJA and ACJL of states had provided for restorative justice, but the modus operandi was not there. But because we made that reference to the fact that we visited, they said no, that we are for the defendant. We cannot be seen to be for both parties. And so the effort we were making, they all are pleased to say that we want to see how the victim is centered. We want to see how the voice of the victim is heard, felt to, deaf ear. So it was really, really difficult to advocate and promote restorative justice. So one way is to see how NGOs, victim support units, first of all, victim support centers, victim support units, and victim-centered NGOs can, take up that mantle to see how to amplify victim voices. It's still a bit of challenge when you are listening to both parties. They want you to just be listening to victims alone. Otherwise, they start saying, oh, you are compromised, oh, you have taken money from the defendant, and then you now want to come and it's very complex right now. So I share in that concern, and I hope that as we keep asking these very key questions and demanding, answers and providing advocacy talking points, we'll be able to achieve that. I think that's just what I wanted to add, and to all the recommendations that Madam Zake has made.
All right, ma'am. Before I ask the next question, I'm using this opportunity at this medium to inform our listeners that you can actually drop your questions in the comments so that we can ask them as the program goes on. So my next question is to you, Mrs. Grace, and I'm asking this from your lens as a lawyer. As a defense lawyer, I know that you've crossed paths to the other side by virtue of restorative justice, but I'm very sure you were once in the shoes of the defense lawyers all over Nigeria. And there's this part of restorative justice that most defense lawyers may not really like, because if we're saying we can settle things, we can try to reduce recidivism, what are lawyers going to eat? If people are not committing crimes, if we're not going to court every day, adjourning, collecting appearance fees, what are we going to eat? So the question is this: from the lens of a defense lawyer, how does it benefit defense lawyers? How does restorative justice benefit us at the end of the day? Because it feels like it is going to take jobs and there might be problems. So that's the question. How does it benefit the defense in a criminal matter?
That's a very hard. Mrs. Akia is laughing.
I'm telling you, it doesn't take their jobs away, really. It only makes them metamorphosize into something else. It only adds to their quality, really. It only adds to their qualification from being a counsel to a mediator. And even mediators do get paid for their roles. So they can actually charge for being a mediator or moderator in any of those kind of processes, whether it's a victim offender mediation or circle sentencing or family circles, they do have a role to play, really. So it's not that it's stripping their jobs away, it's just like bringing them another nomenclature of what they could be doing. Sorry, it's not my question, so please.
No. I think you are providing the very clear context, very, very clear context. In fact, I always say, in my opinion, and this is not a humble opinion because I very well respect the views and perspectives of defense lawyers. The reason I say it, I feel like the fear is very unfounded. I was a litigator, a very core courtroom litigator, before I focused fully on, as the executive director of REGA in my role and administrative role so that I can be able to get more done. And as a core litigator, my only cases were not criminal cases. There's hardly any lawyer who is into litigation that their sole practice is focused or centered on criminal litigation. You're going to get enough money if you know what you're doing in litigation. And also, it's not just criminal litigation that you get to have clients. You get clients from civil litigation. You get clients, doing property laws.
In fact, they say there's no money in criminal litigation.
That is the point I'm even driving
There's
at.
no money in it.
So in fact, they even,
They avoid
at
it.
some point, my boss in practice used to say that if criminal matters come, sometimes he just pushes it to lawyers and say, "Come, Grace, do this because it feels like you can't charge." Many of them are defendants who cannot afford the fees for legal
It's
representation.
just pro bono, right?
Yes, they can't afford professional fees in every sense of the word. But you see, civil litigation, that's where the real
Yeah.
money is. But so, I mean, if you feel like, so many of the times we tend to say that it's people who want to chase briefs, who want to go from one police station to another, who want to just sit in court and, get all the police cases. I don't want to use the word ambulance chasing here, but you know what I mean? It's those people who have that fear, right? And just like the very second point, very important point you also mentioned, look at when ADR came in. I mean, we're still in school when we're hearing all the backlash against ADR, oh, it's going to take jobs from lawyers. Look at how centered ADR has now become in our civil litigation. You now have mediators, certified mediators. Many of them even got certified outside the shores of Nigeria, right? And they get paid to mediate these matters. Some of them foreign matters, right? So it's a means to even get certification in restorative justice. Is a means to diversify, understand this concept. I think the bottom line should be, is it relevant? Is it useful? If the goal in the criminal justice system is public safety, then why do you think that the mega money you are going to be getting from one defendant who is paying you 10,000 because the matter, or 20,000, or however, whatever the amount is, because the matter is going to keep being adjourned, and then you feel that is to be prioritized against a model that clearly assures public safety. I think that there should be more questions to be asked as a lawyer, right? So I feel like
Yes,
fears are unfounded. I have been on a panel where they had to bring the NBA to, ask those key questions because they felt lawyers were asking it and then they needed somebody to answer. And those were my answers. In fact, at the end, part of the recommendation was that we should mainstream RJ to the point or the extent where people get to be certified, and then referrals should be to the people who are certified, so that people who are taking RJ serious get to benefit from RJ programs. And just like Mrs. Akia mentioned, as you are sitting to mediate, as you are sitting to have those victim offender mediation, as you are sitting to, have some of those RJ sessions, facilitate some of those RJ sessions, you would be paid. And some of those sitting allowance would be, if not way better, that is an assumption, than a regular
yes,
appearance gas the fee.
that's
So
true.
I hope
That's
that
true.
answers the question. Yes, please go ahead.
Yes, sorry for cutting in. What you're saying is very true. Because think about it. A criminal case could take like a year or two to be resolved. And if the defendant was only able to pay like 20,000 naira, I think within the first hearing, that money would have been gone, right? So how about taking the 20,000 naira and have 2 or 3 sit-ins, and then the entire case is resolved, and then you don't have to be going to court for 2 years just to settle something that the money had already ended. I mean, think about it, right? And if we were to have the restorative justice, just like you said, it will become an avenue for learning. Definitely, because if you're going to be managing RJ circles, mediating in them, then it means you have to have the knowledge. So it's really an opportunity for the lawyers to learn more about restorative justice. So that's just my thinking. I think we shouldn't be, I think we should be more open-minded to accept changes. I know change is something that is difficult for every one of us, but some changes come for the good. And some changes do have a lot of good in them. Even saving the time is good. One thing that I think from the beginning that we left out while I was introducing or trying to talk about what restorative justice is, I kept saying it's holistic. So I think, let me break being holistic down. Let me break it down. When I say holistic, it means restorative justice is about restoration for the victim, right? It tries to restore the victim to what he previously was before the crime, right? And there is also the second R, which is reparation. It tries to repair the relationship between the accused person and the victim as well. Thirdly, more like goes towards the question of the moderator about the defendant. Restorative justice is also about rehabilitation of the accused person. Because like you said, sorry about that, instead of sending the accused person to prison, you could find a better avenue to rehabilitate him. You're not condemning him. There's what we call, what do you call it by Umbrit? Constructive shaming. Really, instead of taking him to prison, it's just like saying, look, we are not condemning you. What we're saying is that the actions are not good. But we're not saying you're not good. We're saying your actions are not good. So that it makes it easier for the accused person to be accepted, rehabilitated. And then lastly is reintegration. So after that, we agree that it's not just the accused person is not a bad person, but his deeds or actions are what are condemned and we don't want them to happen. He would be reintegrated easily into the community. So there's that thing, there is that stigma about being a criminal or hardened criminal or someone that has gone to prison that is removed by restorative justice. So that's why I say it's holistic. It goes for restoration, reparation, rehabilitation, and reintegration of the accused person. So it covers the victim, it covers the accused person, and also brings the community harmony as well.
Thank you so much for that answer. So we have a question in the comments, and interestingly, the question kind of aligns with the next question that I was going to ask. So I'll ask it together. So first of all, one of the major aims of the criminal justice system is to, one, punish crimes, and secondly, to act as a deterrent for intending offenders. So if we're trying to see a way where the offender is not being punished, so to speak, are we not encroaching on that need for deterrence? And also, like James said, he asked that how can restorative justice be advocated for in corruption cases that are very rampant in Nigeria, considering how rampant they are and the need to send a message of deterrence to other intending offenders. So, in your bio, you were very vast in the whole corruption scene. So I believe you'd be the best fit to answer this question. So how do we adopt restorative justice in corruption cases? And also very importantly, how do we not encroach on the deterrence side of the Nigerian criminal justice system?
All right. First and foremost, I'm writing that's a PhD, but it's uncompleted. So my answers to this would not be conclusive because I'm still working on it. And I'm also very keen on finding out at the end of the day what my results or my answers or conclusion will be after the PhD. So I would not
Our
really
fingers are
preempt
crossed, ma.
that. Yes, but still, I believe so far so good. I believe there are a lot of openings for restorative justice in corruption cases. And having restorative justice in corruption cases brings in the community and would have a way of supporting the community to grow better and will give the community some kind of voice on what they think should be done in cases that affects the public fund because they are the public really. So they should have a say at the end of the day. So how it's going to be it's a center for my research in chapter 4, which I'm still doing. I'm still carrying out a lot of interviews with all the stakeholders. And for instance, the defense counsels, judges who have handled corruption cases, NGOs, CSOs, attorney generals, plea by gain officers, the state council, so many people. And apart from that, I'm also going to have some kind of quantitative data, which is going public to ask members of the public what they think about it and how, if they were to be allowed to participate, how their participation would be. So I will not really and then let me not disclose everything that I'm doing. It's on the pipeline, and I'll be very happy to share the results at the end of it. Yes, regarding to the other part of it, whether it diminishes the deterrence effect, is a very tricky question. Yes and no. Yes and no. If dependent on the offenses, dependent on the type of offenses that we have, I could say yes, if there are offenses that touch human body, like homicide, rape, and what have you. But at the same time, I could say no if we have propriety cases that touch on property and financial crimes. Yes, we could have restorative justice for that. Because think about it, even financial cases are available, no matter how gruesome they are, or they look or sound, or how scandalous they sound, they tend to be what bailable. I remember very clearly one time I was in court and there was a political person involved in the case, and they applied for bail, and I think I wrote a handbook on why that bail should be denied. So at the day of the hearing, the judge, in just 2 or 3 sentences, maybe 5 lines, admitted him to bail. Simply put, it's a bailable offense, and so she grants him bail. Simple, it's her discretion, despite my handout. So generally, yes, it depends on the kind of offenses that we're talking about. So instead of saying that it could be, it would diminish, let's say that restorative justice could come in as complementary in certain offenses, like instead of going through that deterrence, let us take another way out. For instance, my argument here is, let me give you a case scenario. If, for instance, in fact, there is a real English case to this, I think the Cloudworthy case. They were in court. Or let me start with the live example, or my example. If, for instance, I come to your place and I kind of like dashed your windscreen, the windscreen of your car, what would it benefit you if I go to prison? Because if I go to prison, that's the end of it. I'm not going to give any money to repair you, to repair your car. There's nothing like that going to be. It's just going to be I pay fine, which goes to the coffers of the state, or I go to prison. So either ways, if there's any money coming out from me, it's not going to you as the victim whose car has been bashed. It's going directly to the state again. And then I'm going to the prison. And where do you stand? But how about an alternative that says, okay, let's sit down. Why did you do this offense? Why is it happening? How do we stop it from happening? And what do you have to say? How would the defendant be accountable for that thing? And there has to be some kind of admission, confession, yes, I did it. And there is remorse. I'm remorseful about it, and I'm willing to repair his car. And then there could be some kind of undertaking I'm not going to do. And if for any reason I bashed your car, there must be an underlying reason why I did that to you. So you probably, the victim himself has some kind of blame in it. Not in all cases, but in most cases. You find out that the victim also has some kind of blame in it. Not that I'm justifying that the action of the defendant is good. So in those cases, I think the victim will be better off if he has the defendant taking accountability for the offense, paying for the repair. And again, let me point it out. This avenue of restorative justice does not stop a conviction. No, it doesn't stop the conviction. It doesn't stop the court from punishment. It's just a way of making the defendant accountable and responsible for his act. The deterrence has to do with the public interest and the deterrence, but that accountability should be there. So it goes complementary. I hope that answers the question.
Yes, ma, it does. It does. And I even realized that even without the official or the legal aspect of going to court, the state punishing and all of that, even the act of asking the person to restitute is deterrence in itself, because they
Yes,
would normally aim to get away with things like that. But the fact that we're not letting them get away with it and we're asking them to restitute is deterrence in
that's
itself.
excellent. Because there's one article, I think it's by Kathleen Daly, and she points out that whoever said that there is no deterrence in restorative justice. Now, whoever said that, the fact that you will be held accountable for your offense, the fact that you're going to do some kind of social work for the community is enough deterrence, like shaming. Assuming you steal something, for instance, like someone asked in corruption cases, assuming a politically a corrupt officer who's well known. Let me cite an example like this Ahmed Idris, the AG, Accountant General of the Federation, or MFLA, CBN, assuming after all the trial, he's been asked to do some kind of community service, like sweeping the market. Is that not shameful? Everybody will see him. And that is like kind of paying back, right? So that's some kind of deterrence, because if you have honor and integrity, you would not want to do that. So people seeing like people like that doing manual tasks like that will serve as a deterrence, because it's shaming. And secondly, like asking them to repair what they did or to return the money, you're denying them the access to enjoy the, what do you call it, the benefit of their crime. Returning that money that they looted is what? Stopping them from enjoying the benefits of their crime. And then thirdly, if you could ask them to like do something for the community that they have hurt, choose something to do that will be profitable to the people. I think it's better than asking him to pay a paltry amount of money and then choose whether to go to prison or not. Personally, my thinking. Thank you.
Yes, ma'am. Thank you very much for that. So, Mrs. Grace, the next question is for you, and we're moving towards the end of the webinar because of time. But this question is coming as a result of Susan's comments in the comments box. She said that if incorporated, that is, if RJ is incorporated within our criminal justice system, solicitors are winning because once the offender pleads guilty and restorative justice is offered, there's less job, better outcome for your clients, and even more clients for you. And that begs the question of, if we are implementing restorative justice, are we not at the risk of solicitors pressuring defendants into admitting guilt? Because if you admit guilt and you act like you're sorry, we're going to give you something lesser, or quick judgment, or quick resolution of the matter, rather than the long process that it would take. So are we not at the risk of solicitors pressuring their clients into admitting guilt so that the matter would end as fast as possible? Mrs. Grace.
So I would say that to that question, at the risk of saying pressuring, I'll rather say that, there's the leaning towards a plea bargain or something. So that's when you have that pressure, like sometimes take this deal now or something. In restorative justice processes, you hardly will have that kind of pressure. The reason is because ROJ is largely voluntary. They have to be willing to participate in that process, right? So in an ROJ process where you have any of the parties, whether the victims counsel, the communities, the defendant or his counsel, or offender in certain cases or his counsel, pressuring the defendant/offender to admit guilt, the ROJ process is defeated even before it started. Because that element of accountability, you won't find it in that process, is missing, is out the door. So if you pressure them, if you have to pressure them to admit their guilt, the only consequence, the only tenable process you can call that is a plea bargain. Okay, why don't you accept to give up, maybe in corruption cases like Zakia answered, instead of going with the entire 100 million that was embezzled, you're going to give out, or you're going to return 80% or 80 million naira, and then you're going to admit your guilt, right? So that's where you are going to have a distinction between RJ and other processes. I wish we would be able to unpack RJ in this one webinar, but it's impossible. And that's why I believe that we are tending towards scheduling courses on restorative justice so that we can handle some of these elements, distinguish them from other elements like negotiation, like mediation, like conciliation, like ADR itself, so that you don't just reduce RJ to agreement. Do you understand? And then you say, see, these people are saying this is what they call RJ, or they are making people go away with crime. And meanwhile, what is happening is a plea bargain agreement, or a plea bargain process, or a mediation process, or an ADR process. And then they just tag everything as RJ. And then they make a mockery, in quote, of the advocacy you are actually promoting. So there's a very thin line. RJ has elements of some of these things. It has elements of negotiation, of mediation, and some of these other elements. But one of the distinguishing factors is, one, accountability. In an ADR process, most times you're not necessarily holding one person accountable. You just want the matter to be resolved. You want the case resolved. There's resolution at the peak, or at the cross of the ADR process, right? You want it resolved for each of the parties. You want a common ground, right? In RJ, there's necessarily not a common ground. All you want is accountability. All you want to do is understand needs. In ADR, you're not necessarily asking for what led. Well, it may happen. That's why I said some of the times there's intertwining of some of these processes. But you see, in RJ, there's the accountability of what happened, a commitment not to repeat that offense. There's a commitment to a change of lifestyle, right? There's a a commitment to repair the harm that was done. Sometimes necessarily not in tendering an apology, in restituting what was stolen or what was lost or taken in because of the crime. Some of these elements are absent in all these other elements. So that's why we have to understand the concept of restorative justice and then distinguish it from other elements. Even though some of these elements may find their bearing in restorative justice, you need to understand how very distinct restorative justice is. And then to the question around deterrence, I also wanted to ask that, sorry, I just, I'm not on the asking side today. So I also wanted to comment that it's safe to say that what prison does is to help with that element of deterrence. Prisons were built, I don't want us to go into the history of prisons and how, it's the colonial concept became an adopted concept eventually. But let's just focus on what we are doing right now to understand that prisons provide that element of deterrence and punishment. So in ROJ, most times, and especially for the Nigerian context and the type of crimes, if it's for petty offenses, if it's for non-violent offenses, we will always recommend ROJ and non-custodial punishments or sanctions. But you see, in capital offenses, the law will take its course. It will take its full course. So it's not a win for the defendant. Oh, when you commit a crime, we now advocate, we will not introduce restorative justice, and then because of that, you get to get away with the crime. Nah. That's why RJ is not in any way a recommendation or a slap on the wrist or an easy way out of the consequence of crime. No, the RJ process just complements what goes on in the conventional criminal justice system. So you are still going to go through trial, but RJ is going to see how to mitigate, because sometimes the victims want closure, but the criminal justice system doesn't have any modality for listening to the voice of the victim or understanding the needs of the victims in that case. So RG just comes as a complement to understand what the victims need and to see how that need is met, so that it is not only the needs of the offenders that we are tilting towards. So in most felonies or in most capital offenses, as we would regard them in Nigeria, the RJ processes and the criminal conventional process takes its course. We introduce RJ so that if, for example, there are technicalities that would have allowed that person to I don't want to use the word escape the consequence of that crime. I wish we are not at the end. Have we sat down to talk to, sometimes think about the impact of wrong, what's the word now? So when some of the judgments are reached on the grounds of technicalities and you see that defendants get to walk, have we thought about the impact it has on victims in our communities, in our societies? That's one reason why we advocate for restorative justice, so that there's an element, and in criminal cases, even if you admit to committing the crime, in capital offenses, even if you admit to committing the crime, you are still, the court will still record a plea of not guilty, just so that witnesses are still called, and it is they are certain that this crime actually was committed, and it's not that the person was pressured to admit the crime, or one extraneous circumstance made the defendant to admit the crime. Maybe they are not psychologically okay, or whatever, for whatever reason they admit, and then the court just hands out judgments, right, or convictions. So in our criminal justice system, current criminal justice system, in capital offenses, even with a plea of guilt, the criminal justice process still takes its course. What restorative justice does is to bring the victim's voice to the center of that process that has excluded them. And then because of that admission, if it happens, the defendant is able to take, accept accountability, commit to a change of lifestyle, and then give that victim the closure they need. in cases where they need just that. I've seen victims in court where they say, I just want apology. Somebody mentioned it on the call that it happened in the court last week. I just want them to apologize. If you see some of these rape cases, the victims don't want to prosecute. The pain they have is that the defendant is not admitting or accepting to have committed the offense. And that's one thing that, hinders or obstructs public safety. If a victim is someone who has anger issues, who has criminal tendencies, when the person is set free by the court, in quote and unquote, set free by the court, is released on technical grounds and comes back to that community, that's revenge, that unresolved, pain in the victim can lead to another crime. Those are some of the things that RJ resolves. It wants to resolve, it tends or tries to resolve the root of the crime that was committed from his roots, to see how it is taken care of, the victim's needs or voices are centered, and then the offender gets to, number one, face the consequence of their actions, and two, in certain cases, in most cases, become accountable. They are held accountable for their offenses. In many criminal cases we have today, there's no accountability. There's no accountability. So you see that they plead not guilty, witnesses testify, the defense opens, calls witnesses, denies everything. And in certain cases, even if the court finds them guilty, they are even angry that they were found guilty. There's no remorse, because no process opened them up to say, see what happened, see who is impacted by your actions, see how your actions impacted another person. What do you think should be done? But no opportunity for the victim for the offender rather, to go through that process. And because of that, they even feel like they are victims, even though they committed the offense. So RJ is trying to see how to resolve the problems that crimes create and to ensure that we are heading towards public safety. I hope that answers that question.
Yes, it very much answers the question. And I believe that everything that we've discussed already circles us back to the topic of the webinar today, which is restorative justice, an alternative or complement to the Nigerian criminal justice system. And I think that we've been able to establish that we're not trying to kick out the traditional criminal justice system that we have here, where we go to court, the state prosecutes, and the offender goes to jail or is found innocent, not guilty.
Mm-hmm.
We've been able to establish that it is supposed to complement the system. Restorative justice is not saying that offenders should walk free. It is saying that you can as well go to jail and also restitute the victim or give the victim closure, as it were, in any given circumstance. So I believe that this session has been very eye-opening for everybody, as it has been for me, because I had fun and it was very educating. And I believe we cannot exhaust all the questions that surround restorative justice, like you mentioned, but so it's almost impossible to do that. So we'll have to draw the curtains on today's webinar here. I'd just like to get a final comment from both Mrs. Grace and Mrs. Akia, very briefly because of time. So I'll start with Mrs. Grace. Any final word before we draw the curtains?
First of all, I want to gratefully say that I'm happy that people joined to listen to this topic on restorative justice, and to say that there are so many questions that this should bring up in our minds. And because of that, we are hoping that you are a part of the bigger picture to see and then to understand what restorative justice is. There are so many myths around restorative justice, and it won't be fair on the concept and principle of restorative justice that we are running with the myths and not the facts. So on that note, I want to just appreciate everyone for joining. If you still have questions, which we believe you will do, please reach out to us. Reach out to us on info@regafrica.org. Let's see how we can maybe schedule one-on-one sessions to address those concerns. And then if you can be part of the big picture, which is to participate in restorative justice courses that address these elements and, dissect it with sufficient time. It's not what we are trying to do within 1 hour, 30 minutes. RJ is way, way broader than that. So we're looking to see how we can develop courses that people can, sign up for, and then just learn about restorative justice, see how you can be a part of the restorative justice advocacy, and then promoting people-centered justice across Nigeria. It's not a Western concept. It's a concept that was homegrown, but at some point we lost the element in the twists and turns from colonialism and wanting to see what works best. But we want to now bring it back, center restorative justice as what can complement the current criminal justice system. And then we hope you will be a part of that. I hope I've not said too much. I'll yield the mic to Zakia.
Mrs. Zakia, your final comments.
You're muted.
Okay, thank you. You see, restorative justice has so much good in it, so much good in it, but sadly, it's not really understood. And sometimes, let's say, it's grossly misunderstood. And part of my understanding is that people take restorative justice to mean compensation. Like whenever I talk about my topic, everybody will be like, oh, isn't it just to compensate? What does it have to do with corruption? What are we going to compensate? So seriously, there's a lot more to it. And if people will be more aware of it, we would unlock its potentials beyond what we think. Now, I know it's very difficult overnight to just bring in restorative justice. It has to take, it has to have some kind of baby steps. There needs to be serious education and awareness about it. And it's not really an attempt to like overtake the mainstream criminal justice system, but it will work perfectly if it starts with being a complementary system. I mean, even if it's going to overtake it, it will have to start complementing it before it becomes an alternative. And so we should also change our mindsets because restorative justice is not a mate, like a co-wife. Seriously, the defense lawyers are guarding it jealously because they have their own interest, and the judges also have their own interest. No, it's just a paradigm. It's just a mindset that you need to change and see what it does. Now, if you agree, if you're educated about it and you know the good that there is in it, I don't think you will avoid having it. So I believe if there is a will, we will definitely find a way of bringing it back home where it started. And for me, some aspects of it have started with the ACJA, with the introduction of the ACJA. It has, for the first time, recognized the victim, and it takes away that stench from the accused being called an accused to the defendant. It brings about compensation to the victim. In plea bargaining, the victims are being asked to come. So many, maybe a little bit more of that. But still, I still find little problems with all of these things that I've mentioned, despite this enormous milestone that has been achieved. For instance, it clearly makes mention of the victim, and that because the ACJA is introduced to protect the interest of the accused, the victim, and the community, but it doesn't define who the victim is. So as long as that definition is not there, we still have a problem. And secondly, there's that misunderstanding between the two words, compensation, restitution, and what have you. I think we need to properly understand the difference between the two. Restitution is something that the defendant, the accused person, gives to the to the victim, regardless of the fine or what have you. It's given by the defendant to the victim. Compensation is for the state, whether there's conviction, whether there's no conviction, whether the accused has been nabbed, whether he's not been convicted, whatever. As long as a victim is being hurt, then the state has the responsibility to what? Compensate. I'm not sure at any point in time the state is willing to do that. So let's stop confusing a compensation just by heaping it on the defendant. There's compensation, just apply for compensation, blah, blah, blah. Compensation is for the state, and the state shall take responsibility for allowing that crime to have happened, right? And even their voices in the ACJA, like in all laws that we have that refer to the victim, their rights are being couched in a way that is discretionary in manner, you know, even international instruments. They talk about the victim's rights, but they're mostly couched in a way that is not, it's hardly ever enforced or enforceable. It's just a matter of discretion by the prosecutor or the judge himself. So a lot of things like that, when you look at it, there still needs to be done. And also the fact that the defendant has been removed, has that stigma removed from him as being the accused person. I don't think throughout the ACJA that stinge that was removed has had a reflective consequence on the victim. Personally, I don't think so. I mean, if there is that removal of stinge and that stigma of a person called an accused or going to prison, being called a prisoner, then I think it should have a mellowing effect on the victim as well. Then it means that if he's no longer seen as a criminal, so to speak, as the accused person, then it should allow him, it should give him room to confess to his crime, to admit. It's, if not, for me, it's just like giving him a new name. So he's still the same person with the same offense. Nothing has changed, just the name. It's just an old wine in new bottle. So if really there's going to be change of the name of the defendant, then that name that suits him now should have some kind of relieving impact or consequence on the victim as well. So without taking too much of your time, I would like to thank Madam Grace for having me. She just tagged me on it. And I'm actually so happy to be here. And I would keep talking about this anytime, any day. And I'm also happy that she said a lot of people have joined. And I feel happy because I'm able to educate more people. I hope so far I've educated some people about things that they didn't know about RG. I'll be here anytime and I'll answer any question if I can. If I can't, I'll throw it back to Grace. Thank you so much.
Thank you so much for joining in. We indeed learned a lot from you today, and we're very glad that you joined us. Thank you so much, Mrs. Grace, too. And we're very glad that we have you to ourselves in the Abeokuta office so that we can always ask you anything that we want at any time, too. Thank you so much for joining in, everyone. We're so glad to have you here, and we're very humbled that you joined us today. I hope that you've learned one or two things that would spark questions in your minds. And like the ED has said, you can always reach out to us on our socials and also on our website. We'll be very sure to reply you and provide assistance wherever it is that you want or that you may need it. So thank you very much for joining in again. We've come to the end of the webinar today. I hope to see you again very soon on another webinar like this. And I hope that you join in. Thank you so much and enjoy the rest of your day. Bye.
Thank you, Esther. Just a minute, please. I just wanted to acknowledge some of our team members from Ghana. I can see Susan on the call, and I'm thinking as well, not so sure. I saw Kadi Fofona. They joined in from the Gambia. I don't know if you want to just say a little hi, so that we can acknowledge your presence.
Hello. Good afternoon, everybody. Thank you so much for having us. It was really informative. Thank you, Madam Zakira and Grace. I think the
Thank
conversation
you,
was
Susan.
really insightful. And one thing that keep going on my mind is the issue of deterrence. When it came up, everybody thinks that restorative justice is not enough to serve as a deterrence. But I just want to say it's one of the most difficult things that clients have to deal with. Offenders having to accept that I done wrong and I am the one that actually caused somebody having to go through that pain. It's really something so difficult, and I only hope that people understand it that way. It will make it easier for it to grow. And really, once again, thank you everybody for attending. I think this is just the starting, and we can take this to another level for Africa, as you have mentioned that it came from us. We are bringing it back to where it belongs. Thank you.
Thank you, Susan, all the way from Gambia. Our regards to the RJ advocates over there, and we look forward to more engagements between Nigeria and the Gambia. So over to you, Esther. Oh, I think you have closed the meeting. So bye, everyone, and thank you so much for staying the course with us.
Thank you, Grace.
Please
Thank you,
follow our
Susan.
social media handles. Please follow our social media handles and stay in touch with us. Bye, everyone.